Distinguished guests, ladies and gentlemen, friends, this morning it is my distinct pleasure to introduce to you a person who is not just my colleague on the bench of the High Court, but also someone who has become my very dear friend. I'm not going to repeat the dazzling triumphs that His Honour has accumulated over his lifetime in the law so far, whether that be his Rhodes Scholarship, his Professorship of Law at Oxford University, his brilliance as a barrister at 1 Essex Court in London as well as in Perth, his ascension to the Supreme Court of Western Australia, the Federal Court of Australia, and now the High Court. What an outstanding list. Suffice to say, there was a great rivalry as to which country, namely Australia or the United Kingdom, would secure His Honour's services as an apex judge. Thankfully, Australia won. But what sort of person is Justice Edelman? When I joined the court, I was immediately gobsmacked, and that's the right word, by his sheer knowledge and mastery of the law, especially private law. His memory on the court is legendary, and his energy is prodigious. Since 2017, that remarkable talent has been used to illuminate and clarify the law in High Court judgments, which are always incredibly lucid and erudite. You might be forgiven for thinking that with the combination of being on the one hand a lawyer and on the other hand a person with such ineffable intelligence, Justice Edelman should probably be both arrogant and conceited. Unsurprisingly, this combination has produced lawyers with such attributes in abundance. But he is nothing like that. He is generous, kind, courteous, and modest. When I arrived at the court, he gave me the warmest of welcomes, and every time I see him, I most sincerely feel that warmth once more. His natural inclination is to help and serve others and his nation. He is duty's servant and a model judge. If I may paraphrase Alexander Pope, as so many have done before, nature and nature's laws lay hid at night. God said, let Edelman be, and all was light. Ladies and gentlemen, my friend, my brother, James Edelman.
Justice Stewart, well, what an introduction. I can only thank you from the bottom of my heart for an introduction like that at the very first legal speech that I've given that my wife has attended. Having spent the last 2 years following her around at speech after speech, book launch after book launch, and hearing very admiring praise for all her speeches and her work and her books, all I can say is I'm now just going to assume, as if she doesn't attend any other speech of mine, I'll let her assume that all introductions of me are like that. Can I also particularly thank Mr Ian Callanan and Mr Xavier Boffa for their invitation to speak this morning. It's a real delight to be back here. The very first of these conferences that I attended, I was still just out of law school, and it seemed to me then that even in that time where the marketplace of ideas, to use Oliver Wendell Holmes's phrase, was much broader than it is now, this was still a society and a conference where ideas triumphed and the marketplace of ideas was well and truly alive. And I think this morning's the speeches and this morning's discussion shows that that really still is the case with this society. The last time that I was at the podium as a presenter at this conference was almost exactly 20 years ago. Well, I was invited to the podium, but as it turned out, an earlier commitment that I'd made materialised in a different state on the same day. I provided my conference paper to a colleague and a friend at UWA to present on my behalf. He very kindly rewrote it. The revised paper was described to me by a different colleague in what I'm sure was something of a caricature, as a proposal for a Marxist redistribution of public natural resources. I should say that I'd been warned by the Speaker that he wished the work to be his own and that it was possible that the final product might not very closely resemble my paper. But on this occasion, the only people to have read this paper in advance are my colleagues and dear friends, Justices Stewart and Derrington, but neither has suggested that the paper should be reworked from a Marxist perspective. In November last year, in a case called NZYQ and the Minister for Immigration and Citizenship and Multicultural Affairs, the High Court of Australia unanimously overturned its earlier decision from 2004 in a case called Al-Kateb and Godwin. But the High Court did so in an unusual way. The court didn't reopen or depart from what was described as the statutory interpretation holding of the majority in Al-Kateb. It only reopened and departed from the constitutional holding in that case. My view for why the constitutional holding should have been reopened was set out separately from the other members of the court, although in the same judgment. My view was that the constitutional holding in Al-Kateb was inconsistent with the unchallenged principles set out by this court in a case called Chu Cheng Lim and Minister for Immigration. I'll refer to that as the decision in Lim. The unanswered questions concerning the overruling of Al-Kateb and Godwin that I want to address this morning concern the precise role of precedent in a decision by the High Court to reopen and depart from one of its earlier decisions. I'll use the decision in Al-Kateb and Godwin to discuss these questions in respect of decisions on statutory and constitutional interpretation. It's remarkable, however, that the most clarity that's usually provided when a submission's made to the High Court of Australia that it should overrule one of its earlier decisions is just by reference to a list of factors. Yet how the matters in that list should be applied and the weight that each of them should bear can be very controversial. This controversy was brought into sharp focus a couple of months before the decision in the NZYQ case, in a case called Vanderstock and Victoria, in which 4 members of the High Court substantially reduced the powers of the states to impose taxation and overturned the earlier decision of the High Court in Dickinson's Arcade in Tasmania. As Justice Stewart observed in that case, the decision that they overturned in Dickinson's Arcade had been affirmed, followed, or not departed from on 9 occasions over the course of half a century. In overturning that decision, their Honours also rejected the reasoning of at least 21 present and past members of the court. Justice Gordon described the overruling as not construing the text of the Constitution but rewriting it. Justice Stewart described the new rule as departing from a principle that had been carefully worked out in a large number of cases. So what is the methodology that could lead some judges to support a wholesale constitutional change in the teeth of decades of precedent and the views, sometimes very strongly held, by 21 other justices of the court? Well, in the early days of the High Court, before strong streams of jurisprudence had emerged, Sir Isaac Isaacs appeared to express the view that when a judge of the High Court is satisfied that a constitutional precedent is unprincipled, the judge's obligation is to follow their conscience in relation to the view of principle and completely to exclude any consequential considerations that might arise from overruling past precedent. But even in those early days, Sir Isaac Isaacs was careful to require that the judge's view be that the true state of the law was plainly in conflict with what had been held by the judge's judicial predecessors. He said this, he said, "If then we find the law to be plainly in conflict with what we or any of our predecessors erroneously thought it to be, we have, as I conceive, no right to choose between giving effect to the law and maintaining an incorrect interpretation. It is not, in my opinion, better that the court should be persistently wrong than it should be ultimately right." The point that I want to make this morning, by reference to the overruling of Al-Kateb, is to add some nuance to this view. Naturally, the starting point before a Justice of the High Court can depart from a previous decision of the court is a strong conviction that the previous decision was incorrect as a matter of precedent. I agree with Sir Isaac Isaacs that this conviction must be sufficiently strongly held that the judge can say that the decision was, in the language of previous authorities on precedent, manifestly wrong or plainly erroneous, or, in the more recent and polite collegiate euphemism, that there are compelling reasons of principle to the contrary. But that conviction about lack of principle should only be one dimension of the analysis. As an overall summary of the paper that I will come to present today, I come to honour the remarks of Sir Harry Gibbs in the Second Territorial Senator's case, when he said this of Sir Isaac Isaac's approach. He said, "Like most generalisations, the statement can be misleading. No justice is entitled to ignore the decisions and reasoning of his predecessors and to arrive at his own judgment as though the pages of the law reports were blank, or as though the authority of a decision did not survive beyond the rising of the court. A justice, unlike a legislator, cannot introduce a program of reform which sets at naught decisions formally made and principles formally established. It's only after the most careful and respectful consideration of the earlier decision, and after giving due weight to all the circumstances, that a justice may give effect to his own opinions in preference to an earlier decision of the court." In the First Territorial Senator's case, Sir Harry Gibbs had dissented along with Chief Justice Barwick and Justice Stephen. In the Second Territorial Senator's case, in which he set out these points, Sir Harry explained that he still thought that the First Territorial Senator's case was wrongly decided. It may be that he thought that it was plainly wrong, but he nevertheless followed it as a matter of precedent. He said that no new arguments had been presented and the consequences were too great to justify the overruling of the decision, including the expectations of the people of the territories who had acted on the decision in the First Territorial Senator's case. In John and the Federal Commissioner of Taxation in 1989, 5 members of the High Court considered the decision of Chief Justice Gibbs some years after the First Territorial Senator's case, in a case called Commonwealth and Hospital Contribution Fund. The justices in John summarised 4 matters that Sir Harry Gibbs had set out as considerations for whether to overrule a decision. Those matters are: 1, whether the earlier decision rested on a principle carefully worked out in a succession of cases; 2, whether there was a difference between the reasons of justices constituting the majority; 3, whether the decision had achieved a useful result or had led to considerable inconvenience; and 4, whether the earlier decision had been independently acted upon. Unfortunately, in treating these 4 factors as something of a shopping list, it's sometimes common to overlook a distinction that Sir Harry had implicitly drawn in the Second Territorial Senator's case between 2 dimensions of those factors. On the one hand, the first 2 factors are concerned with matters of principle. They focus on the cogency of the reasoning and the principle upon which the decision is based, including the fit that the decision has with the corpus of precedent and the operation of the Constitution or the statute. On the other hand, the second 2 factors are concerned with the consequences of the decision, the usefulness of the result, whether it had been acted upon. In short, the first dimension is concerned with considerations of principle, involving fit and justification for the legal rule, while the second dimension is concerned with the consequences of overturning the legal rule. These 2 dimensions are not always entirely separate, but the first has the greatest weight. What I intend to do this morning is to illustrate the importance of understanding these 2 dimensions of overruling by reference to the overruling of a case where their application presented a number of very difficult and unanswered questions, and that is the case of Al-Kateb. In December 2000, a 24-year-old Palestinian man called Mr. Al-Kateb arrived in Australia by vessel without a passport and without an Australian visa. Mr. Al-Kateb was stateless. He'd lived most of his life in Kuwait, but he had no citizenship there or anywhere else. He fell within a class of stateless people who were not covered by the Refugees Convention. Mr. Al-Kateb was taken into immigration detention. He was detained under Section 189(1) of the Migration Act, which, when read with Section 196(1), requires that a person who is known or reasonably suspected to be an unlawful non-citizen be detained by an immigration officer and be kept in immigration detention until he or she is removed from Australia. Mr. Al-Kateb applied for a protection visa. He claimed that although he wasn't one of the hundreds of thousands of other Palestinians who'd been deported from Kuwait after the Gulf War, he nevertheless feared persecution by the Kuwaiti authorities, including arrest, imprisonment and torture. Mr. Al-Kateb's application for a protection visa was refused, and proceedings for judicial review of that refusal decision and appeal were dismissed. During this time, Mr Al-Kateb remained in immigration detention. In June 2002, Mr Al-Kateb told the relevant department that he did wish to be removed from Australia and he asked to be returned to Kuwait. He said that if it wasn't possible to return him to Kuwait, he wished to be sent to Gaza. The department investigated whether Mr Al-Kateb could be removed to Kuwait, Egypt, the Palestinian territories, Syria or Jordan. All the investigations were unsuccessful. No other country was identified to which he could be removed. An application by Mr Al-Kateb, which sought various forms of relief, including declarations as to the unlawful nature of his potentially indefinite detention for habeas corpus and release, was refused on the 3rd of April 2003, although the judges concluded that removal from Australia is not reasonably practicable in the present time because there is no real likelihood or prospect of removal in the reasonably foreseeable future. Subsequently, and during Mr Al-Kateb's potentially indefinite detention, the full court of the Federal Court of Australia handed down its decision in a case called Minister for Immigration and Al-Masri. In that decision, the full court unanimously held that the power of the Commonwealth Executive under Section 196 of the Migration Act to keep a person in detention under Section 189 was subject to an implied limitation. The implied limitation was that the power of detention did not apply where there was no real prospect of removal and thus no real prospect of detention coming to an end within any reasonably foreseeable timeframe. Since the full court concluded that the provisions did not authorise indefinite detention, the full court didn't need to decide whether indefinite detention was constitutionally valid. Nevertheless, the full court expressed serious doubt about the constitutional validity of a provision if it had been interpreted to allow indefinite detention. The doubt that was expressed by the court was said to arise due to the principle espoused by the High Court in the Lim case, which I'll come to shortly. Shortly after the Al-Masri decision, orders were made by consent releasing Mr Al-Kateb from immigration detention subject to conditions. Nevertheless, an appeal was still removed to the High Court from the primary judge's refusal to make declarations as to the unlawful nature of Mr Al-Kateb's potentially indefinite detention. The High Court, by a majority of 4-3, overruled the decision in Al-Masri. The majority was comprised of Justices McHugh, Hayne, Callanan and Hayden. The dissentients were Chief Justice Gleeson, Justice Gummow and Justice Kirby. The ratio decidendi of the case comprised two rules of the case which are sometimes described as holdings. The first holding of the majority was its statutory interpretation holding. It was essentially that the requirements of Section 189 and 196 together with Section 198, meant that executive detention of a suspected unlawful non-citizen must continue until removal or deportation or the grant of a visa. The second holding of the majority was its constitutional holding. Expressed at a high level of generality, this holding was that such executive detention was compatible with Chapter 3 of the Constitution. The reasons of Justice Callanan differed from the other three members of the majority in one key respect. Justice Callanan treated the relevant purpose as one to be assessed by reference to the subjective rather than the objective purposes of the executive. Due to that difference, the second holding regarding the compatibility of Mr Al-Kateb's potentially indefinite detention with Chapter 3 of the Constitution can only be expressed as part of a ratio decidendi at a high level of generality in order to encompass all four members of the majority. The result in Al-Kateb was, and for nearly 2 decades remained, highly unstable. The three dissenting judges had dissented in strong terms, supporting the earlier decision in Al-Masri. As early as 2005, the full court of the Federal Court was speculating on the possibility that Al-Kateb might be overruled by rejecting the constitutional holding based on the High Court's earlier decision in Lim. In 2012, one of the minority judges in Al-Kateb, Justice Gummow, and another, Justice Bell, were critical of the statutory interpretation holding of the majority in Al-Kateb. In 2014, the full court of the Federal Court speculated that the decision in Al-Kateb might at some stage be overturned. In 2022, a Justice of the Federal Court explained that a habeas application would have been upheld if the court were not bound by the decision in Al-Kateb, And in 2023, the full court of the Federal Court observed that the decision of the High Court in Al-Kateb has been the subject of much commentary, much of it adverse, and that it is sometimes suggested that the High Court might come to a different decision if the issue were to be considered again. In light of all that, a case came along called NZYQ. NZYQ was a case brought directly in the High Court as a special case. NZYQ brought a direct challenge to the decision in Al-Kateb in relation to both the statutory interpretation holding that Section 189 and 196, as a matter of statutory interpretation, authorised the detention of NZYQ, and secondly, a challenge to the constitutional holding that such statutory authority for detention was consistent with Chapter 3 of the Constitution. The defendants submitted that the circumstances of NZYQ were distinguishable from those of Mr Al-Kateb, because unlike Mr Al-Kateb, NZYQ had been refused a safe haven enterprise visa because he was considered to be a danger to the Australian community. The Solicitor General of the Commonwealth relied in this respect on remarks by Chief Justice Gleeson in dissent in Al-Kateb that if a detainee was regarded as a dangerous person, that might be a matter that could affect the detainee's right to be released from administrative detention or the terms and conditions of the release. But in the NZYQ case, it was never suggested that there was any legal principle that could lead to any different legal treatment of NZYQ compared with Mr Al-Kateb. There was also no argument about any power to impose any terms and conditions on the writ of habeas corpus. However, in the NZYQ case, the Solicitor General of the Commonwealth did point to the consequences of overturning the result in Al-Kateb. Evidence was tendered by consent that showed that numerous aliens were held in detention who had committed very serious offences, but for whom there might be no real prospect of removal from Australia becoming practicable in the reasonably foreseeable future. Those matters were rightly relied upon as relevant to a consideration of whether to grant leave to reopen the decision in Al-Kateb. So that brings me to the principles concerning reopening past decisions and precedent of the High Court. In most cases in the High Court where leave is sought to reopen an earlier decision, the application is to depart from the result of the case. But sometimes the application might only be to depart from the reasoning in the case. In other words, it might be argued that the ratio decidendi of the case, the reasons for deciding, might be wrong, although the result is correct for different reasons. As I explained in a case called Vunalagi, in these unusual cases, the court might depart from all or part of the ratio decidendi of the case, even if the result of the case is considered to be right for different reasons. The common premise of the parties in the NZYQ case was even more unusual. NZYQ did not seek leave just to reopen and overrule the result in Al-Kateb, nor did NZYQ seek leave just to reopen and overrule part of the reasoning in Al-Kateb. Instead, NZYQ sought leave separately to reopen and overturn each of two different aspects of the reasoning, with separate challenges to each part of the reasoning. The defendants adopted that submission and that assumption in oral submissions, so the special case proceeded on the basis that leave was required separately to reopen first the statutory interpretation holding and secondly the constitutional holding. The potential difficulties in the parties' assumptions were not explored in oral or written submissions in the High Court. The court in the NZYQ case therefore confined itself to the observation that it was common ground that leave to reopen Al-Kateb should be considered separately for each of the two holdings of the majority. One potential difficulty of assuming that the two holdings needed to be reopened separately is that many of the matters to be considered in assessing the consequences of reopening and departing from either of the holdings in Al-Kateb required consideration of whether the court would depart from both holdings. To reiterate, those consequential decisions are whether the decision as a whole had achieved a useful result, or whether it had led to inconvenience and the extent to which it had been independently acted upon. Despite the overlap in the consideration of these consequential matters, in some cases it will be possible to conclude that one holding might be reopened and overruled and another might not. The reason that it's sometimes possible to do so is because, as I mentioned at the start, greater weight in the analysis has always been attached to issues of principle, namely the correctness as a matter of principle of the decision, including its place in a stream of authority, rather than that which is attached merely to the consequences. The overruling of Al-Kateb itself is a good example of this. On the one hand, the justifications for and against the statutory interpretation in Al-Kateb were arguably finely balanced, even if different judges had sometimes expressed their opposing conclusions in strong terms. On the other hand, the defendant in the NZYQ case argued that the constitutional validity of Al-Kateb was not a matter of fine balance, because if the court concluded it was inconsistent with the principle of in lim, then it was inconsistent with a principle that had not been challenged and one that was accepted by both sides to be part of the entrenched stream of constitutional discourse. A larger obstacle to the existence of a separate requirement for leave to reopen different holdings that form part of the same ratio decidendi in a case might, however, arise if the two holdings were not sufficiently independent of each other. For instance, in a case where questions of both statutory and constitutional interpretation arise, it's not uncommon for an argument to be made that if the better interpretation of the provision would lead it to be unconstitutional, then Section 15 A of the Act's Interpretation Act in the Commonwealth should operate so that the meaning of the provision is read down or reinterpreted in order to ensure that the provision is constitutionally valid. On this view, the statutory and constitutional holdings would not be sufficiently independent of each other. But that issue didn't arise in the NZYQ case, because neither NZYQ nor the defendant relied on the general command in Section 15A to read down or reinterpret the meaning of the statutory provisions. Instead, NZYQ relied upon the very specific command in Section 3 A of the Migration Act, which is not concerned with interpretation or reading of a provision. It's an instruction to courts that, with some exceptions that were not relevant, where a provision would have some invalid constitutional operation, then the meaning of that provision, the unchanged meaning of that provision, is to have every valid application other than the invalid applications. This technique is long established. It's been described by me and by others in the High Court as a technique of disapplication or partial disapplication to distinguish it from the process of reading or interpreting the meaning of statutory words. It's a difference between adopting a narrower meaning of a provision and, in this case, adopting a narrower application of a provision. So I move then to the way the Johns factors work before I turn to how they were applied in Al-Kateb. As I explained at the outset, it's common for the High Court, when considering whether to overrule one of its previous decisions, to have regard to what's known as the John factors, a list of 4 non-exhaustive considerations of Sir Harry Gibbs that had been summarised by the High Court in John and Federal Commissioner of Taxation. But as the High Court said in the NZYQ case, those considerations may have different weight. To reiterate, the first 2 factors concern the force of the principle upon which the decision in question rests. Was the principle a cogent one? Was it understood in the same way by the justices who accepted it? Was it carefully developed in a succession of cases? By contrast with matters concerning principle, the second 2 factors concern the consequences of overruling, the usefulness or inconvenience of the decision, and whether it had been independently acted upon outside the courts. The first 2 factors affect the force with which a belief is held that the result of a decision cannot be justified. In that sense, they are concerned with questions of justification rather than consequences. As I explained in Vunalagi, even a decision that in our isolation is contrary to legal principle might be justified if, for example, it had become embedded and around which streams of jurisprudence had developed. For instance, a decision that might be thought to be contrary to principle might have been reached by unanimous reasoning which is developed by a succession of cases in related areas of law. By contrast, the second 2 questions concerning the consequences of overruling the result in an earlier case or departing from its ratio decidendi, irrespective of the force with which it's thought to be wrong, apply in a different way. In Vunalagi, the point was put in this way. It was said, although both dimensions of consideration are important, greater importance lies with the dimension of justification than that is concerned with the correctness of the result or reasoning as a matter of legal principle and structural legal integrity. Even an argument against reconsideration based on widespread practical ramifications cannot prevail if it's clear that the interpretation is incorrect in the sense of being unprincipled and structurally inconsistent. As I've explained, it might be argued that the justifications for and against the statutory interpretation of Al-Kateb were finely balanced. On the one hand, the language of section 189 and 196 of the Migration Act appeared clear. The words were described by Justice Hayne in the majority in Al-Kateb as intractable. The words appear to suggest that a person reasonably suspected by an immigration officer to be an unlawful non-citizen must be detained and must be kept in immigration and detention until he or she is removed from Australia. There is no exception for a person for whom there is no real prospect of removal becoming practicable in the reasonably foreseeable future. On the other hand, the meaning of words is never truly intractable when they are interpreted in context. When context is taken into account, it can be obvious, for example, that there's just been a mistake in the language that's been used. There are legal decisions that have held, and sometimes by the highest courts in various countries, that black means white, that consistent means inconsistent. That was one of Justice Dixon's most famous judgments. That the 12th of January, as Lord Hoffmann said in Manai, means the 13th of January. A French statute once made it a criminal offence for a person to alight from a train that was not moving. The word not had been erroneously included. Context can also shape the purpose of a provision, which in turn shapes the meaning and application of the text. The purpose of a provision is interpreted according to the ordinary rules of statutory interpretation. In the application of those rules, the purpose of a provision has to be set at the proper level of generality, which is usually more general than just the express or semantic terms of the provision. For instance, no party or intervener in Al-Kateb or in NZYQ suggested that the purpose of section 189 and 196 of the Migration Act was at such a high level of generality that it was just one of detaining aliens. That would just be a purpose of detention for the sake of it. Rather, as the Solicitor General for the Commonwealth neatly crystallised the view, the position of the majority in Al-Kateb on the purpose of the provisions could be expressed in words adapted from Justice Dixon, that it was detention pending removal. In short, it was a purpose of removal of particular classes of alien from Australia. The division between the majority and the minority on the statutory interpretation holding in Al-Kateb therefore reduced to whether the purpose of section 189 and 196 of the Migration Act should be stated at the high level of generality, removal of classes of alien from Australia, or at a level of much greater specificity, but not one reflected in the text of the provision, which provided that removal of classes of alien for whom there is no reasonable prospect of removal becoming practicable in the reasonably foreseeable future. If the purpose was stated at that level of specificity and with that exclusion, then the purpose could confine the application of the provisions. It would impliedly confine it so that power couldn't be extended to detain unlawful non-citizens for whom there was no reasonable prospect of removal becoming practicable in the reasonably foreseeable future. That specific approach to purpose was most clearly taken in the minority in Al-Kateb by Justice Gummow. He described the purpose as facilitating removal from Australia, which is reasonably in prospect. That purpose would mean that a person, as I've said, for whom there's no real prospect of removal in the reasonably foreseeable future could not be removed. But for one matter, there is little or no textual or contextual indication of such a confined purpose. That one matter is a principle that's been described as the principle of legality. The principle of legality is a principle of statutory interpretation that treats the intention of the Parliament's taken to have as conforming with the reasonable expectations based on past experience. The more fundamental a right, privilege or liberty that legislation appears to affect, and the greater the derogation of that right, privilege or liberty, the less likely that Parliament will be taken to have had that intention. The principle of legality is sometimes described as a presumption. In a speech in 2021, James Allsop gave examples of common presumptions, such as that intention or knowledge is an element of a criminal offence, even if it's not expressly mentioned, or, as Justice Bradley said this morning, that hearings will be conducted with procedural fairness, even if there's no express provision to that effect. James Allsop explained that these presumptions arise out of the basic moral values that far predate the creation of our Constitution. And although the presumptions can be displaced by statutory language, we must not forget that the act of presuming is based on the contention that the people who entrusted power to the government are entitled to expect that the power will be exercised in a predictable, equal and fair manner. The principle of legality can have great force where the question of statutory interpretation concerns whether a person should entirely lose their fundamental right to liberty or whether a provision should extend to deprive a person of their liberty. It has less force, but still some force, where there is plainly an intention to remove liberty, but the question is merely the extent to which a person or people will be deprived of their liberty. As Chief Justice French, Justices Kiefel and Bells said of the lesser force of the principle of legality in that context, it's a principle of construction which is not put to one side as of little assistance, where the purpose of the relevant statute involves an interference with liberty. It's properly applied in that case to the choice of that construction, if one be reasonably open, which involves the least interference with liberty. Nevertheless, as I've said, the principle operates only as an interpretive presumption. If Parliament's words are clear, they have to be given effect. As Justice Callanan observed in Al-Kateb, a presumption cannot be made, even against legislation that is contrary to an international obligation, to displace the clear and unambiguous words of Parliament. The issue in Al-Kateb ultimately then reduced to whether the words of the legislation in their context were sufficiently clear to preclude an alternative purpose and meaning being derived with the assistance of the so-called principle of legality. It was ultimately a question of evaluative judgment, whether the principle of legality had sufficient force to reduce the purpose and meaning of Section 189 and 196 of the Migration Act from one of removal of the relevant class of aliens to one that was more specific and qualified, such as Justice Gummow put it, facilitating removal from Australia, which is reasonably in prospect. The justification for Al-Kateb on the statutory interpretation holding was one which, even after careful reflection, different minds could reach different conclusions. In Al-Kateb itself, 4 minds reached one conclusion and 3 reached the other. In deciding whether the statutory interpretation holding in Al-Kateb should be reopened, the considerations of principle were said to be ones on which there were reasonable arguments on both sides. That finely balanced dimension of principle was said to favour the reopening of the decision, but it could more easily be overwhelmed by the consequential or pragmatic considerations which weighed against reopening. Ultimately, in NZYQ, it was the consequential or pragmatic considerations that precluded the court from reopening the statutory interpretation holding in Al-Kateb. As the joint reasons in the NZYQ case explained, in the nearly 2 decades since the decision in Al-Kateb, the Commonwealth Parliament had passed legislation amending the Migration Act in numerous respects. The Commonwealth Parliament had relied upon the decision in Al-Kateb. In circumstances in which the arguments of principle about statutory interpretation were treated by both sides as being finely balanced, the consequential consideration of nearly 2 decades of reliance by the Commonwealth Parliament was highly significant. In the NZYQ case, the Minister also relied upon a further important consequence. The Minister suggested that a consequence of overturning the result would be the release from detention of people such as NZYQ who'd committed serious offences and might be a danger to the Australian community. It's true that, independently of immigration detention, a range of options exist under state laws for orders that can be made by the courts in relation to people upon their release from prison, or prior to it if they are considered to be a sufficient threat to the safety of the community. But that was not an answer to the submission of the Minister, because the laws that empower those preventative measures did not exist for offences generally at the Commonwealth level. So that brings me back to the point that I made at the start of the paper. The Johns factors concerning overruling, which were summarised from those first set out by Sir Harry Gibbs, were not all factors of the same weight. Although the same consequences weighed against reopening both the statutory interpretation holding and the constitutional holding in Al-Kateb, the considerations of principle were ones that would have and have always been treated as having greater weight. In the NZYQ case, the dispositive reasoning of 6 members of the court was broader than mine on the question of principle. 6 members of the court held that the purpose of the Commonwealth Parliament to deport NZYQ was not legitimate and was therefore punitive. Since their honours rejected the legitimacy of the purpose, they did not need to engage with whether the purpose, if legitimate, was reasonably capable of being seen as necessary. By contrast, I held that the Commonwealth Parliament had a legitimate purpose which could be characterised at a high level of generality, as the majority had in Al-Kateb, of removal of classes of aliens from Australia. In that respect, I preferred and prefer the views of Justice Callanan in Al-Kateb, that the general purpose of deportation has been traditionally and rightly recognised as a legitimate purpose of the Commonwealth Parliament, and it's not a purpose that becomes punitive merely because it cannot be achieved in the reasonably foreseeable future in some cases. The Commonwealth Parliament passes many laws where the purpose of those laws cannot be implemented to its full effect in every single instance of their application. This is no different from ordinary life. The example I gave in NZYQ was a specialist sports squad which has a program of training for the Olympics. That purpose remains legitimate, even if some members of the squad might not have any prospect of making the Olympics in the reasonably foreseeable future. So too, the general purpose of the Commonwealth Parliament's law remains legitimate, even if it's not achieved in every single instance of its application. In my view, however, the means adopted by the Parliament in achieving the purpose were not proportionate. That reference to proportionate is shorthand for the unchallenged requirement expressed in the Lim case that the means of executive detention must be reasonably capable of being seen as necessary for a legitimate purpose. The difficulty of principle with the constitutional holding in Al-Kateb, in my view, was that it was inconsistent with that proportionality principle in Lim. The decision in Lim was not challenged and had been developed and relied upon in numerous cases over more than 30 years. Hence, although the statutory interpretation holding was a matter upon which reasonable minds might differ, the decision in Lim made it extremely difficult to justify the constitutional holding in Al-Kateb. As I explained in the NZYQ case, my view was that Section 189 and 196 of the Migration Act were inconsistent with that requirement in Lim, because executive detention of those aliens was not reasonably capable of being seen as necessary for their removal if they could not practically be removed. As Justice McHugh, who was himself in the majority in Al-Kateb, later said in re Woolley, none of the justices in the majority in Al-Kateb had applied the reasonably capable of being seen as necessary test as the determinative test for ascertaining whether the purpose of the detention was punitive. In short, the considerations of legal principle, the first 2 weighty considerations developed from Sir Harry Gibbs, including the unchallenged and long-standing decision of the court in Lim, outweighed the consequential considerations in relation to the constitutional holding. In conclusion then, the most basic message from this speech is a very simple one. It's a message about the importance of nuance. Lawyers love lists. The list provided in John of the factors to consider whether reopening or overruling a High Court decision was lifted from the reasoning of Sir Harry Gibbs, who had thought long and hard about this issue, at least since his wrestle with conscience in the second Territorial Senators case. But the list should not be understood without the application of the nuance that Sir Harry knew to underlie it, and which has long been applied. Otherwise, like a very young child who has a bowl of alphabet soup but knows no words, we'll be left with a list of factors but without any vocabulary of principles with which to arrange them. Thank you.
Mr Callanan, Wendy Callanan, Justices Edelman and Stewart, other distinguished guests, ladies and gentlemen. I was absolutely delighted when Xavier Boffa asked me to move a vote of thanks on behalf of Justice Edelman for delivering this year's Sir Harry Gibbs Memorial Oration. Although I confess I was a little less delighted when he suggested that I provide a short critique of His Honour's paper. No, it's not that I'm averse to providing critiques of legal writing. Indeed, that's actually part of my job description. But my being lower in the hierarchy of courts means that on occasion, His Honour Justice Edelman marks my judicial homework. So, were it to be the case that some element of His Honour's paper led me into vehement disagreement, I might have found myself in somewhat of a bind. Happily, though, I ought not have been worried, because there's nothing within His Honour's speech, at least the version he gave to me, which differs slightly from the one he delivered today. He took out all the parts about Marxism and the distribution of resources. So I didn't disagree with anything, and I don't think there's anything in it which can be criticised. Your Honour, your paper was an epistemological tour de force, if I might say. Please remember those words when you're next describing my judgments on appeal. And it's one that clarifies to many the arcane mystery which surrounds the manner in which the High Court departs from its previous decisions. Now, it's axiomatic that when the High Court departs from its previous decisions, that it will involve a matter of significance. Of course it will. It will also be controversial. Of course it will. But in Your Honour's address today, you've demonstrated that when the High Court does disagree with its previous decisions and changes direction, it does so in a considered and not whimsical manner. On saying that, I did see my close and dear friend, Professor James Allen, outside, and I see that he's speaking later, and he might take me to task for that. But the principles Your Honour's described today show clearly the manner in which the court works. Your Honour has also provided a clear explication of the principles identified by Sir Harry Gibbs in the Second Territorial Senator's case, and that their application requires an understanding of the duality of factors concerning principle on the one hand and those concerned with consequences or pragmatic considerations on the other. And Your Honour suggested, and perhaps not surprisingly, that when the High Court recognises a bad principle, it's an anathema to our civil society that it continue, and such that the court cannot maintain it despite the potential for significant practical consequences following the overturning of an earlier decision. And then Your Honour demonstrated in your paper the practical application of those principles by reference to the recent decision in NZYQ, which overturned the long-standing decision in Al-Kateb, though Your Honour differed from your fellow judges on the court as to the constitutional flaw in the detention provisions, being that it was the disproportionate response to a legitimate statutory purpose which resulted in invalidity, rather than that the purpose of the provisions was not legitimate. Your Honour's analysis was both deft and, if I may say so, respectful to your fellow judges. Ladies and gentlemen, I have the great fortune to have the friendship of both Justices Edelman and Stewart, and I say that for only one reason, that by knowing them, I'm acutely aware of the enormous pressure under which they work and the ceaseless demands on their time. That's because they always blame me the quantity of work whenever I ask for a lunch, but I assume that they're telling me the truth. But apart from their judicial duties, both of them are actively involved in numerous extracurricular legal activities, and in the case of Justice Edelman, he's the author and editor of legal texts. He also teaches from time to time. So it is especially generous of Your Honour Justice Edelman to take the time from your hectic schedule to prepare and deliver this year's Sir Harry Gibbs Memorial Oration. Ladies and gentlemen, would you again please show your appreciation to Justice Edelman in the customary manner.